Hello. One of the most, I would say, infamous or maybe hated parts of our legal system is procedure. It makes everything long, it makes everything expensive, inefficient. Uh, it forces people to wait for years until the judgment, or if there is an appeal for like many years sometimes. Uh, it makes it all complicated. It makes you in need for lawyers, which is expensive, and so forth. So there are reasons to be dissatisfied and disappointed with legal procedure. And yet, through centuries, it stays there and becomes only more and more detailed and nuanced. Um, and not only because of some malicious intent of those jurists who always want public to pay more, though that cannot be excluded, I suppose. But that's not the major reason. The major reason, I would say, is because, to simplify, procedure is justice. Or, to put it in other words, procedure is something that makes and puts as much obstacles in the way of injustice as possible. There are many examples in the history when some dissatisfied king or tyrant or some elected even body tried to bypass the procedure and to make justice as they saw fit. And strangely and inevitably, it ended up in corruption, oppression, and the situation with justice itself only became worse. So, what is so important in procedure that it makes justice? It's not a coincidence that procedural faults, procedural deficiencies are among those most strong reasons to overturn some judgment. Uh, Factual situations, legal reasoning, it might be done and appreciated one way or another, but procedure should be always there for everything else to be working. At least that's the experience, that's the outcome of centuries of development of the justice system. And one of the most important, as you probably heard of it one in one word or another, is audi alteram partem or audi alteram partem, uh, which basically says, let the other party to present their position, like listen to the other party also, which means that no, at least in the ideal judicial world, no decision should be made until the other party is heard. And therefore, decisions made in the absence of the other party, if there is no evidence that there was an honest attempt to find the other party and invite, and that the other party simply ignored that invitation. So usually there should be an evidence that the other party knew of the judicial proceeding, that the other party had a right, an opportunity to present uh, their position, their observations, and so forth. And only after that, a judge might render a judgment. Also, complicated, yes, complicated. Evidence rules are usually there to provide as much as possible for the judge an opportunity to see like real, objective, factual evidence from both sides, which necessarily makes the process longer and more complicated because there are rules, uh, particularly like codified rules, uh, telling you how to obtain your evidence, how to present your evidence, in order to, as much as possible, exclude false evidence, exclude self-serving evidence, exclude evidence that was created specifically in anticipation of such a trial, exclude illegally obtained evidence, and so forth. Also to, as much as possible, diminish the situation when one party brings like unreasonably huge amount of evidence specifically to make it all impossibly complicated. So evidence rules are really important, and it's, again, not a coincidence that the courts are usually careful and strict, again, as much as possible, about observing those rules as long as they are maintaining the first one, like listen to the other party, so make the way for the other party's evidence as well. It's true that in reality, parties themselves have this unfortunate tendency to ignore the requirements regarding the evidence. So at the end of the day, the evidence is insufficient, incomplete, deficient in many ways, sometimes like clearly wrong and incorrect. But if there were no those rules, that would be the predominant case in almost every hearing, and then we would be in a courtroom where the arguments are basically who shouts louder, uh, which is something that the evidence rules are called to prevent. It is possible that some party is using a better financial position or better initial situation or sometimes better political situation to impede and to put obstacles and to alter the course of this administration of justice. And for that, at least in Quebec, at least under the Code of Civil Procedure in Quebec, there are rules concerning interim hearings and case management where the judge could be called to just decide on some particular procedural point to let the case go on. Because again, without that, there might be just blocks on the road. Another important part of procedural rules is the requirement or requirements for the way how the judgment should be rendered. First of all, that there is some time period so that nobody waits for the judgment infinitely. And second, that any judgment, even a small, even a short judgment, should deliver reasons, and those reasons should address arguments of the parties, both factual and legal, so that whoever would be analyzing the judgment would see that the judge actually applied rules to the facts and not simply his or her personal sympathies or like personal prejudice or sort of stereotype or something like that. So procedural rules, as much as possible, try to compensate the fact that the justice is rendered by human beings with all the faulty nature of a human being. And without that, as again history shows, even the wisest of them have a tendency to take into account the cultural predispositions, their even moods or something like that, procedure is there to compensate for that as much as possible. Also, a possibility of appeal, where the case is not heard again anew from the beginning. No. The appeal courts are usually analyzing how correctly the initial procedure was observed and the judgment was rendered, according to the rules again. So, to sum up, the procedural rules are there to compensate for known, well-known examples of misuse or abuse of the judicial system. But of course, there is a way to use all those procedural rules against the judicial system, against the justice system. And again, in an attempt to compensate for that, to counter that, there are rules regarding abuse of procedure, meaning that if somebody is using procedure for the sake of procedure to make the case longer, to prevent actually the other party from presenting their position, from presenting their evidence, blocking the courts from pushing the case to advance, preventing the judge from analyzing certain facts and legal arguments based on, again, the just pure and like unreasonable procedural issues brought up. For that, if the judge sees that, because at the end of the day, it's all up to the judge anyway, the judge might punish for that. So, if we have at least some hope that our justice system is just and is administered to uphold justice and fairness, not only some just blind letter of the law, then on one hand, we need human judges who could apply the law to the actual human situation. On the other hand, we need those procedural rules to compensate for the human nature of everyone participating: parties, lawyers, clerks, even the judge. And this is why I started this episode with such a statement: procedure is justice. Maybe procedure is not all the justice we need, but without procedure, without due process, it's significantly harder to get to justice. In my opinion, in my humble opinion. Thank you and have a nice day.